Please be seated. Yes, Mr. Joss.
Your Honours, we'd now like to say a little bit another category of witness. Witnesses I will describe as international witnesses. Now, of course, everything we've already submitted about other witnesses applies to international witnesses. But specifically, in this regard, Mr. Thayer, in his submissions, was at pains to defend somewhat passionately the honour and integrity of both Colonel Kingory and General Nicolai. Briefly going to deal with Kingory now and Nicolai a little later when I address the issue of the alleged threats to him. So far as Kingory is concerned, he of course again doesn't touch directly on my client's case. And in many ways, to the Guevara defence, he was a witness of secondary importance. In the defence brief, at page 156, paragraph 181, we make some robust submissions about the quality of his evidence. Mr. Thayer seeks to defend this gentleman's honour and courage. We say that's really neither here nor there. It's his testimony that matters. And his testimony was, to put it kindly, of extremely poor quality. But of course, that doesn't really take the matter that much further, because the issue, again, is can you rely upon what he says, so far as the prosecution is concerned, beyond a reasonable doubt? And we submit the answer to that is emphatically no. Now, we would invite you to look critically and carefully at international witnesses. They play an important part in Guevaro's case. Because they were not themselves the warring parties, that may be putting it slightly inelegantly, but I'm sure you know what I mean, it doesn't mean that they must be truthful, let alone accurate. To raise them to some sort of higher strata of witness, as Mr. Thayer in effect seeks to do, is a mistake. As individuals, we contend that they are as prone to inaccuracy and exaggeration as any other human being. In particular, in the highly stressful and emotional situations that these people found themselves in relation to the events surrounding this case. Furthermore, so far as this case is concerned, there is no getting away from the plain fact that there was, to put it mildly, a real motivation on the part of some of these international witnesses to downplay any moral culpability, perceived or real, by either themselves or other members of the international community, that their actions, or more likely inactions, contributed even in some small way to the events that we've heard about over the last 3 years, and in particular, of course, the mass murder. Put simply, we suggest you need to examine the evidence of many of these witnesses with a highly critical eye. We can put it no better than a quote that I put to Edward Joseph on the 24th of August 2007 at the end of my cross-examination at 14262. The quote, in fact, in the transcript is slightly wrong, and the quotation comes from the book Death of Yugoslavia, in the acknowledgement section of that book by Little and Silber, a highly acclaimed account of the war. And what the authors said there, and what I put to Mr. Joseph, was as follows: to write any contemporary account of the Yugoslav wars is to navigate the thick waters, not so much of deliberate dishonesty, but of a contrived self-deceit. This applies not only to many of the combatants, but also, sadly, to those who came with good intentions to try to make peace. Your Honour, we echo those words and adopt them by way of comment about witnesses in this case in general and international witnesses in particular. And we suggest that they are sentiments and words well worth bearing in mind throughout your deliberations. I'm going to move on to a completely separate topic and in a moment deal with some errors that we allege in the prosecution brief. But before I do that, on behalf of my team, let me hold my hands up and say we made a rather bad mistake in our brief, and I think Mr. Thayer had spotted it, but was gentleman enough not to mention it to you. Unfortunately, our paragraph numbering goes wrong, starts again on at least 2 occasions, and so in order to refer to our brief, it's necessary to refer to the page number and the paragraph number. Mr. Thayer was good enough to do that without drawing your attention to it. As I say, I've not actually spoken to him, but I suspect he spotted the point, and I'm grateful to his courtesy in that regard. So far as the prosecution brief is concerned, they rely on 6D284, a document which was not admitted into evidence. That's at page 49, footnote 344 of their brief. It was put in part to Kosovats at T30387, but wasn't actually tendered into evidence. Next, at paragraph 1754, footnote 4248, the prosecution say that when Mladic and Milovanovic were away, people will report to Guerrero. They cite in support of this Milovanovic, but what he actually said was that they would report to either General Dukic or General Guerrero as the most senior members of the main staff where Mladic or Milovanovic were away. That's at 12305. Next, paragraph 1775, footnote 4295. The prosecution have relied on the evidence of Skrbich to say that Mladic also knew that Guerrero was at the Probiciats IKM. Skrbich actually said at 15619 that, quote, General Mladic should have known, end quote, whether an assistant commander would go to an IKM. He did not say in the particular instance that he did in fact know whether Guerrero went to that IKM at that time. Next, at paragraph 1801, the prosecution state in relation to Guerrero's alleged order P45 that, quote, he took a direct role in the capture and detention of Muslim prisoners and personally branded the Muslims as inveterate criminals and villains, end quote. However, that's not a fair characterization of that document, which of course the defence suggests there's insufficient evidence to attribute to General Guerrero in any event. What the document said was, amongst them are, let me correct that, let me get it right, among them are inveterate criminals and villains. In passing, when dealing with that particular assertion in paragraph 1801, the prosecution say, quote, this order undoubtedly led to innumerable abuses by VRS soldiers against Muslims from the column, end quote. This, we suggest, Your Honours, is pure hyperbole. It's totally without support in the evidence. It's not a reasonable conclusion at all, let alone one proved beyond reasonable doubt. Our next point relates to paragraph 1806, footnote 4342. The prosecution state that Ptolemy's proposal, P192, and Mladic's final order, 5DP35, also known but not admitted as P2897, of 13th of July, when the fact that it went to Guerrero was not a fluke, because it was wholly within Guerrero's competencies. And in the paragraph I've just given, they cite for this proposition Skirbich's testimony at 5616 to 15616 to 15617. And they say, quote, General Skirbich testified that points 1 and 4 of Mladic's final order fell within Guerrero's remit, end quote. This is in fact misleading, as Skirbich was only shown P192. He wasn't shown 5DP35, which, as I've already said, is also the same as P2897. The point is that 1 and 4 of these two documents are completely different. They say completely different things. They've confused the tenor of Skirbich's testimony. The relevant bit I'm going to read to try and help unravel this confusion. The question was, all right, and then you believe that under point 1, prohibiting access to all unauthorized individuals filming and photographing of the prisoners, that part would be General Guerrero's task. And Skirbich's reply was, it falls under the sector led by General Guerrero, but only this second part, filming and photographing prisoners, because the banning of all uninvited persons is something that the military police were to perform. I hope that clarifies it. At paragraph 1807, footnote 4346, the prosecution state that Ptolemy addressed this new proposal to Guerrero because he was the most senior general. They cite Milovanović's testimony at 12368 in support. In fact, Milovanović only said, quote, probably, I think, end quote, because Guerrero was the oldest officer, the oldest general in the main staff. Next topic I'd like to briefly address, Your Honours, is something that I have alluded to before, I think in oral submissions rather than written submissions, and that is the appeals chamber decision in the Perlich case of the 26th of February 2009, titled Presentation of Documents by the Prosecution in Cross-Examination of Defence Witnesses. We suggest that this decision has clarified this particular subject, and had that decision been known at an earlier stage of this case, it would, we contend, significantly have affected the introduction of a large number of documents admitted on the application of the prosecution post 98 bis. The reality is that the test that this trial chamber set down in its decision of the 17th of December 2008 is very different to the law as now set down and clarified by the appeals chamber. In the light of the appeals chamber decision, we contend that you must examine all material introduced by the prosecution post 98 bis with the greatest of circumspection, and in particular in the light of the test as laid down by the appeals chamber. And this leads on to another legal issue, which is that of notice. The defence have complained in their final brief about the changing nature of the prosecution case, both by way of pleading in the indictment and also by way of notice. This included JEPA and the shifting allegations as to General Guevaro's alleged presence there, dealt with at page 262 to 265 of the brief. Our basic point is, why have a particularised indictment at all? Guevaro's alleged contribution to the JCE is set out in paragraph 76. These were the areas the defence needed to address. These are the areas we suggest of Guevaro's alleged contribution that you need to determine in your judgment. The importance of this does not need stressing or explaining. The defence asks rhetorically, what is the point of particularisation at all if the prosecution case can chop, change, shift in the way that it has? We adopt what Madame Popović said so far as this topic is concerned, in particular her reliance on this trial chamber's own decision of the 31st of May 2006, and in effect the failure by the prosecution to abide by that particular decision. Perhaps I could move on and deal with this in a slightly more specific way, so far as some of the allegations that are now made against General Guevaro that are of real significance. The first is so far as convoys are concerned. The prosecution make much of Guevaro's alleged role in restricting UN and humanitarian aid resupply convoys in paragraphs 217 to 218, 223 and 1765 to 1769 of their final brief. This allegation does not appear in the indictment. Whilst the defence have to some degree addressed the prosecution's vague pre-trial brief assertions as to Guevaro's alleged role in restricting fuel to UNPROFOR at pages 188 to 193 of our brief, this in no way compensates for the prejudice now caused by the defence by having no notice of the wider convoy and humanitarian aid allegations. If it was the prosecution's case that Guevaro contributed to the alleged JCE by assisting to restrict UN and humanitarian aid resupply convoys, then we suggest the law on this is abundantly clear from the Popović appeal judgment, at paragraphs 89 to 90. The acts and conduct of Guevaro in alleging restricting such convoys should have been specifically set out in paragraph 76 of the indictment. We note learned friend Mr. McCloskey's response at 34313 to a similar point raised by the Miletich defence, and we contend this has no application to Guevaro's case. This is because Mr. McCloskey pointed to paragraphs 50 to 54 of the indictment as particularising the convoy allegations against Miletich in paragraph 75. Of course, we don't comment on whether or not paragraphs 50 to 54 do put Miletich on sufficient notice, which are also cross-referenced in paragraph 76. I beg your pardon. But they plainly do not provide sufficient specificity of the case against Guevaro, as he's mentioned nowhere amongst them. In addition to that, we contend that Mr. McCloskey made no mention of the convoy allegations in his opening statement in relation to Guevaro, which was something he relied upon when replying to Madame Popović's submission. We urge the trial chamber to entirely disregard the prosecution brief as to Guevaro's alleged role in restricting UN and humanitarian aid resupply convoys. This allegation has not been properly pleaded, and we have not been put on proper notice as to its existence. Two separate points, I'm bound to say. A similar point arises so far as Directive 7 is concerned, and what the prosecution now say is an important issue, namely Guerrero's alleged attendance at the meeting in Bielina and Zvornik in 1992. We object to the prosecution allegations, and I'm going to be specific here, in paragraphs 28 to 32 of the prosecution's final brief, 56 to 61, 70, 1757 to 1763 and 1765, as well as their closing submission at 34051, and then a few pages later at 34056. As to Guerrero's purported knowledge of and steps towards implementing the 6 strategic goals prior to the 8th of March 1995. These allegations are absent from the indictment, prosecution pre-trial brief, as well as the prosecution's opening statement. We submit this as an example of prejudicial surprise. The defence, to flesh this out if I may, object to the prosecution's use of these matters not as mere historical background utilised to place the material facts pleaded against Guerrero in context, but rather their purported use by the prosecution as allegations material to the common criminal objective of the JCE to forcibly transfer the Muslim populations of Srebrenica and Djepa. We suggest that the accused is entitled to proper particularity of the allegations in the indictment, and we also note that the trial chamber has the power to exclude evidence on the basis that the principles of fairness require due notice or uncertainty, and further support for this can be found in the case I've already cited, Kupreskic, 23rd of October 2001, Appeals Chamber Judgment at paragraph 92. Finally on this topic, the defence also make a related but broader submission that any evidence related both to Guerrero's attendance at and knowledge gleaned from the Bielina and Zvornik meetings, in addition to his knowledge of the 6 strategic goals and Directive 4, is relevant only for background and context to the charges in the indictment. This is because, on any reading, these matters fall temporarily outside the scope of the indictment. For the avoidance of doubt, we contend this applies to paragraphs 28 to 32, 56 to 61, 70, 1757 to 1762.
Thank you for slowing down.
Brief.
Yes. The interpreters.
I'm grateful.
Slowing down.
I apologise to the interpreters, and I'm grateful to your honours for bringing that to my attention. The earliest date.
Probably you need to repeat the last part, referring to the para numbers.
For the record, yeah.
28 to 32, 56 to 61, 70, as well as 1757 to 1762. The indictment clearly states that the earliest date upon which the common criminal objective of the JCE to forcibly transfer can said to have come into existence is on the 8th of March 1995. The defence also view as instructive in this regard the fact that the only mention of the 6 strategic goals and Directive 4 is outlined in the indictment under a heading Background. That's at paragraphs 19 to 21 of the indictment. We submit that the trial chamber ought to limit its reliance upon such evidence to mere clarification of the background and context of the charges in the indictment at the most. It would be improper to rely upon such evidence in order to establish the individual criminal responsibility of the accused. On a related but different point, Your Honours, we wish to draw your attention to what we regard as sweeping conclusions made by the prosecution as to the integral elements of the alleged JCE, which are simply unsubstantiated by evidence. We submit that the assertions that I'm about to refer to are conclusions which are critical to determining the individual responsibility of our client, that is, his knowledge of the alleged common criminal purpose of the JCE, and they indicate the dearth of evidence against him so far as the charges in the indictment are concerned. In particular, we refer to paragraph 1744, where the brief states, from his position in the main staff since its inception, Guevara was fully informed of and actively participating in the RS and VRS policy to remove the Muslim civilian population from eastern Bosnia as set forth in the 6 strategic objectives and Directive 4 and 7. A similar point arises so far as paragraph 1747 is concerned, where the prosecution, I'm going to paraphrase, alleged Guevara's responsibility to inform, quote, the officers and troops of the important goals of the RS and VRS of separating the Muslim population from the Serbian population and the reasons behind this goal, end quote. And finally, paragraphs 1760, which deals with the discussions that Bielina and Zvornik, the prosecution say, quote, there can be no doubt that Guevara has specific knowledge of the policy of ethnic cleansing as set out in Directive 4. Now, the Guevara defence, Your Honours, are between the rock and a hard place, because we have made these complaints to you and we ask you to rule in our favour upon them. But nonetheless, some of these issues have arisen. In particular, we suggest they've arisen very late in this case. And such evidence as there are, it may be you'll be against us, and we feel we'd be failing in our duty to our client not to address these issues. So notwithstanding our submissions as to lack of notice, the changing nature of the prosecution case, the fact that much of this case we suggest is unsupported by admissible evidence, we take a belt and braces approach. And I'm going to pass the baton to Mr. Kurgovich, who's going to address you on some of the issues that I have just alluded to.
Thank you, Mr. Joss. Mr. Kurgovich.
Dobar dan, časni sude.
Good morning, Your Honours and distinguished colleagues.
Časni sude.
Your Honours, as my colleague, Mr. Joss, has just said, the question on General Guerra's part in the removal of the population of Eastern Bosnia was posed for the first time by the prosecutor in his final brief, where in detail he presented accusations against him linked to this topic. With regard to the 6 strategic goals, which the prosecutor in his final brief, transcript page 34050, calls the gospel truth of ethnic separation, the position of the defense is presented in the final brief on page 121. And we consider that the trial chamber in the Krajisnik trial made a reasonable ruling and determined that the strategic goals do not have an unlawful character, nor do they contain anything incriminating within them.
Vezano za te strateške
Linked to those strategic goals, in paragraph 1757 of their final brief, the prosecutor mentions the meeting in Bielina in September 1992. Which, according to the allegations of the prosecution, was attended by General Guerrero. Through the prosecutor's interpretation of that particular meeting, the 6 strategic goals become the main topic of that meeting. However, Your Honours, that is just not true. If you look at the testimony of witness Simic, for example, transcript page 28649 to 28651, you will see that the purpose of that meeting was quite different. The conflict between paramilitary troops and the Army of Republika Srpska in Bijeljina, and the strategic goals are mentioned just in passing.
vađenje, pominjanja.
So, extracting that portion of the meeting, for which the prosecutor has no evidence to show whether Guerrero in fact took part, leads you to making the wrong conclusion. And that is that whenever there is mention of those 6 strategic goals in any context, that has to be the main topic, and that the VRS has no better business to attend to but to discuss the subject of ethnic cleansing.
Nastavijući u istom stilu,
Carrying on along the same lines through paragraphs 1759 and 1760 of the prosecution brief, the prosecutor deals with the seminar in Zvornik and tries to link it up to Directive Number 4. However, Your Honours, there is not a shred of evidence to show that that meeting had anything to do with Directive Number 4. And if you look at the contents of the order for preparation of the military political consultation in Zvornik, which is P4221 and P4222, you can see that nowhere is the topic of this seminar Directive Number 4. Your Honours, Directive 4, as the witnesses said, is a confidential document and represents a state secret. Witness Dagisha Masal, transcript page T29055, spoke about the treatment of documents which are labelled state secret, as is the case with Directive 4. The witness clearly stated that apart from the individuals who were directly included in the drafting of documents of this nature, nobody was allowed to know of the contents of those documents. The drafters of those documents are duty-bound to keep them secret. And with respect to their knowledge about the subjects of these treated in these documents, they had to keep them to themselves and were not allowed to disseminate. That is on transcript page T29055. Bearing all this in mind, Your Honours, it would be highly unlikely and improbable that a large meeting of the type the meeting was in Zvornik, attended by many people from different social structures, civilians, soldiers, officers holding different ranks from different units, to openly discuss top-level state and military secrets. Furthermore, testifying on the 25th of February 2009, transcript page 32075, witness Pandorović, when asked by the prosecutor, responded and said that there was no mention of Directive 4 at that meeting, and no other witness confirmed that any directive was mentioned at all, nor did the prosecution move evidence in that direction. For want of a better, the argument which the prosecutor uses to establish a link is General Jovanović's speech, in which he mentions some duties and assignments with respect to certain built-up localities in Bosnia. However, this argument is insufficient because the duties and the settlements that are mentioned in General Jovanović's speech do not coincide with the duties and localities mentioned in Directive 4. According to Exhibit P4402, Jovanović mentioned the following places: Vitnica, Sapna, Teočak, Cerska, Žepa, Srebrenica, and Goražde. In order to contrive an artificial link with Directive 4, in which only 4 of these 7 settlements are mentioned, the prosecutor, in his brief, intentionally fails to mention the remaining 3 settlements. He just takes what suits him in order to make this link, which, when we look at the context of Jovanović's entire sentence, leads us to doubt as to what was actually said at the seminar and discussed at the seminar in Zvornik. Anyway, the prosecutor practically acknowledges the shortcomings in para 17660, and he says that in the presence of a number of individuals from the political and military leadership, the plans and goals from Directive 4 must have been discussed. It was in English, must have been discussed. Which, Your Honours, the defence would like to invite the trial chamber to see that the beyond reasonable doubt test has not been proved. Your Honours, looking at all this and bringing into and linking up these 2 meetings, the prosecutor is contriving evidence, wanting to show that at that time there was a consciousness on the part of General Guerra. And I'd like to say that before this meeting in Bijeljina, General Guerra sends a letter on the 20th of June, in fact, 1992, which is 60-129, in which he cautions for the umpteenth time what kind of treatment the civilian population should receive in Bosnia-Herzegovina, especially those of different ethnicities. Now, if he's sending out this caution and warning people about this matter, he states his attitude. Would he then discuss matters in this way about strategic goals in the sense that the prosecution views it? So between these 2 events, on the 16th of October 1992, General Guerra sends guidelines for punishing the perpetrators of criminal acts to the military prosecutor. Does that mean that he's sending proposals to be found guilty himself if he refers to Directive 4 or the goals in that directive which are questionable? In one way, he takes part in that, and another way, he proposes that he be sanctioned himself. Your Honours, I'm now going to deal with the alleged participation of General Guerra in the writing of Directive 7. Now, this accusation was first put forward in the prosecution final brief. And this accusation that General Guerra took part in the drafting of Directive 7 is not mentioned by the prosecutor in the indictment or in the pretrial brief or indeed in his opening statement. His position about this matter, the prosecutor changes at the very end of this trial. As my learned friend Mr. Joss said, that General Guerra must have taken part in the writing and drafting of that directive because allegedly he used the full method, as it was called, in its elaboration. Now, this court has heard a number of witnesses who testified about
Mr. Joss.
Čak ponovit ću paragraf 17.
Let me repeat, the paragraph is 1765.
Transkript.
Okay.
It wasn't in the transcript.
Među ovim svjedocima su tužioci i svjedoci
Among these prosecutors, we have Petar Skrbić, Mirko Tribić, Nedeljko Trkulja, and defense witnesses Ljubo Bradović, Novica Simić, Ratko Miljanović, and Slobodan Kosovac. However, even a superficial analysis
za
Let me repeat for the record the names of those witnesses. Petar Škrbić, Mirko Trivić, Nedeljko Trkulja, and Miletić's witnesses Ljubo Obradović, Novica Simić, Ratko Miljanović, and Slobodan Kosovac. However, even a superficial analysis of the testimony brings into doubt the conclusion whereby all these witnesses are these witnesses are making only theoretical comments on the general nature in which documents in the VRS were drafted. And according to their own acknowledgement, none of these witnesses in their military careers ever took part in the writing of a single directive, nor did they write a single directive. Therefore, none of these witnesses, when referring to directives in general, were not in a position to directly personally confirm the joint thesis of the Miletić and prosecutor's defense that Directive 7 was allegedly drafted by means of what was called the full method. First of all, Your Honours, from the title of Directive 7 itself, we see without a doubt that it is a directive of the Supreme Command, which leads us to a separate methodology in the elaboration of that document. With respect to the manner in which directives were written in general, the prosecutor, in his final brief, paragraph 1672, wrongly interprets its own witness Milovanović when he says that the assistants were consulted with respect to the drafting of the directive. However, Milovanović in his testimony clearly states that when the guidelines were given by the Supreme Command, then it is not indispensable and assistant commanders need not be consulted, which excludes the application of the so-called full method. And this is to be found on transcript 12274 to 12276 of the testimony.
The only valid written piece of evidence as to how directives were written, including Directive 7, who provided the guidelines and how the information necessary was collected, was 6D311. Those are bullet points proposed to the President of the Republika Srpska for the directive on special measures in the Eastern Bosnia Core zone of responsibility. Witness Novica Simić first confirmed that those were the bullet points for Directive 7, and then, following an objection from the Miletić defense, he changed his answer, but the document speaks for itself. That's transcript page 28, 610. Your Honours, if the common position of the prosecutor and the Miletić defense on the application of the full method in the drafting of Directive 7 were correct, then the following two qualified witnesses would have, in view of their positions at the time, would have to be involved in the drafting of the directive. One is witness Škrbić, Assistant Commander for Personnel and Mobilization of the VRS main staff at the time of the drafting of Directive 7 and Directive 7.1. He says, however, that he had never seen Directive 7 before he was shown it by the prosecution. Even less had he participated in its drafting. Transcript page 15.517 and 15.518. Witness Miljanović, the assistant of General Đukić and assistant commander for logistics of the VRS main staff, said that in March 1995 he had not seen or participated in the drafting of Directive 7 and 7.1, transcript page 28.957. Furthermore, witness Obradović and witness Kosovac agree that the Directive 7 itself does not contain any clues as to how the directive was written. Transcript pages 30.256 to 30.258. Regardless of this, and attempting to confirm his theory on the so-called full method of drafting of Directive 7, the prosecutor quotes part of the Milenko-Lazić evidence in paragraph 1765, where the witness speaks in very general terms on the work of the command. Also, transcript page 28.475. Ignoring this, as I said, the prosecutor quotes part of the evidence of Milenko-Lazić concerning the work of the command. There is no doubt that witness Lazić was qualified to speak about this. From June 1992 until May 1993, he was assistant chief for operations and training at the VRS main staff. Transcript page T21723 and exhibit B3178. Referring to Lazić, the prosecutor deliberately avoids to comment on the other answers provided by the same witness regarding Directive 7 and Directive 4. Witness Lazić clearly says that he had no knowledge on how the directive was drafted. Pages 21.807 and 21.808. With reference to Directive 4, which was written at a time when the witness worked at the main staff himself, Lazić clearly denies that the full method was applied. He testifies that Directive 4 was written by the Chief of Staff himself, so that neither he, Lazić, although he was a member of the same staff and ex officio authorized to draft such documents, nor others were acquainted with any details from this directive. Transcript page T21829. Unlike the aforesaid witnesses, who had never participated in the drafting of directives themselves, this court has also heard two persons who personally wrote some of them. Prosecution witness Milovanović confirms that he personally drafted Directive 4, T12195 and T12199. The Miletić defense witness Dragis Shamasal, an operations officer of the main staff, drafted Directive 9, describing it in his testimony as the result of the abridged method of work by the VRS commander, chief of the main staff of the VRS, and the witness himself as operations officer, T29069.
Svedok Milovanović.
On transcript pages T1, 295 says, the prosecution witness Milovanović says that he personally drafted a directive as chief of the main staff. Where are the full methods here? Where is teamwork? Where is the participation of other people? Your Honours, these two witnesses confirm in no uncertain terms that only the person designated by the commander, usually the chief of staff, is the person who drafts the directive. All these theories about teamwork in the command are blown out of the water when we start discussing the coming into being of Directives 4 and 7, which are key issues in this case. Look, Your Honours, at evidence of General Djukic. You will see that what Djukic said about the writing of directives and the work of the staff is confirmed by Milovanović and Dragiša Masal, Exhibits 6D313 and 6D315. The argument used by the prosecutor in corroboration of his theory about the full method and the implication of Gvero in the writing of Directive 7 is the fact that they include point 6.7, which bears the title Moral and Psychological Support of Combat Activities. Insufficient, but the only argument that the prosecutor has. According to the Miletić and prosecution logic, just one transcript correction, it was point 6.1. The contents of this paragraph would have to emanate logically from Gvero's organ for morale, religious and legal affairs. This argument is easily overturned by the testimony of prosecution witness Škrbić, T15549, and Miletić's expert Kosovac, T30243 to 30246. Both these witnesses testify that apart from the heading, no part of this paragraph falls into the remit of the organ for morale, nor was it written by a qualified and trained military person. Your Honours, not only is there no evidence in this case to show that General Gvero participated in the writing of Directive 7, there is equally no evidence that he was never familiar with it. Let me go back for a moment. Your Honours, I'm sorry, there's an interpretation issue. Just a moment.
Moja rečenica je bila da nema.
What I said was that there is no evidence that General Guerrero was acquainted with Directive 7.
Vratit ću se na trenutak na iskaze svedoka.
Let me go back for a moment to the evidence of Škrbić and Miljanović on another important point. Both these witnesses, members of the main staff, testify that they had not seen either Directive 7 or Directive 7.1. The evidence of Masal and Obradović will assist us in understanding how it was possible that two members of the main staff had never seen such an important document. As I said, speaking about the meeting in Zvornik, witness Masal, transcript page 29055, speaks about documents marked state secret or constitute a state secret, as was the case with Directives 4 and 7. And he explains that save for the persons directly involved in the drafting of such documents, no one else should know anything about their contents. Witness Obradović explains that Directive number 7 was kept in a special safe box, transcript 28343. Furthermore, witness Masal explains that anyone and everyone involved in the writing of a directive must sign it to confirm their participation in the drafting or to indicate authorship. If the joint theory of the prosecution and the Miletić defense is that the directive was drafted by the main staff, why there is no indication that that it was a product of the main staff? To put it briefly, it has not been proven beyond a reasonable doubt that Milan Guerrero participated in the drafting of Directive 7. As far as the role of General Guerrero in the restriction of humanitarian aid is concerned, it is not superfluous for me, I believe, Your Honours, that Milan Guerrero was not charged with restricting humanitarian aid. However, the prosecution trial brief is full of allegations in this regard. Let us start in chronological order. The prosecution invokes two documents from December 1994, that is outside the context and the time of the indictment, trying to show as evidence of Guerrero's alleged participation in authorizing convoys of humanitarian aid, although the said documents have absolutely nothing to do either with the convoys or with the humanitarian aid.
Documents P4153 and P4152, Your Honours, speak of individuals and vehicles crossing the state border between the Republika Srpska and Yugoslavia. That is to say, the route from Belgrade to Sarajevo, Zvornik, Bratunac and Srebrenica, Banja Koviljača and Republika Srpska. In both these cases, we're dealing with information about the crossing of state borders by individuals and not goods. There are no humanitarian convoys, no humanitarian aid or humanitarian goods. Paragraph 1767 of the prosecutor's final brief once again implies the restriction of humanitarian assistance, once again unfounded. When witness Kralj expounded on a prosecution exhibit, and the number was P 4036. He explained, in response to my question, what this document was about, because the prosecutor had pulled it out of context, and that is on transcript page 29378 and 29379. And here they were discussing meetings of the Commission for the implementation of the peace agreement. I should like to remind you, Your Honours, of the testimony of witness Kral from that portion of the transcript where General Guerrero, saying that General Guerrero was a member of the Commission for the implementation of the peace agreement in Bosnia-Herzegovina from December 1994 to the end of April 1995, except in March 1995, when, because of an injury during a traffic accident, he was absent from the main staff and was not performing his duties there. And that is on page T24099 of the transcript. All the activities of General Guerrero as a member of the said commission evolved during this particular period of time. At that time, during that period, that is to say from December to April 1994, with the exception of the month of March, you will see that his name was mentioned in connection with these activities. When the Muslim side, at the end of April 1995, as is common knowledge, in a unilateral way interrupted the agreement on a ceasefire, the peace agreement was cut short, and therefore General Guerrero's activities in that regard. In our final brief, we deal in part with the meetings. However, I'd like to remind you of Prosecution Exhibit P2936, page 2, item 7, and the agenda there. In his final brief, the prosecutor, when questioning General Smith, he depicted the meeting as saying that Guerrero had come and talked about humanitarian aid. But just take a look at the agenda. Point number 1, the continuation or prolongation on the agreement, extension of the agreement on a ceasefire, a cessation of hostilities. Just one sentence by General Guerrero pulled out of context after the official part of the meeting was over. And that helps the prosecutor to try and show that Guerrero was implicated in the context of restricting humanitarian aid. As a member of that commission, General Guerrero attended various meetings linked to the implementation of the peace agreement. And at these meetings, Your Honours, meetings were agreed upon for regional commissions in places throughout Bosnia-Herzegovina. That is Exhibit 5D 1418. In an attempt to depict General Guerrero and to strike a link between him and the restrictions on the humanitarian aid convoys, the prosecutor tries, by a handwritten addition on documents, to tie in Guerrero and his authority with respect to limiting and restricting those convoys. Now, if you look at that document itself, Your Honours, P4316, you will see that the individual who has written in the portion and does not know what the meeting was about because they weren't present, is simply seeking information from members of the Commission in order to learn whether what it says in the document was actually agreed at the Commission meeting. So it's not consultation, it's seeking information about whether this subject was discussed by the Commission at its meeting or not. Furthermore, paragraph 1768 of the prosecution's final brief attempts, yet again, to prove that Guerrero knew and that he received various documents linked to the convoy. Especially paragraph 1767 is characteristically contradictory. The prosecutor accepts the fact that witness Kral could not identify the initials on document P4036. However, he nonetheless says that General Guerra did initial the document, as well as the following documents: P4028, P4015, P4039, P3999, and P4040. The prosecutor tried to link this up by comparing the said initials on P4036 with another, as he says, characteristic set of initials on a document dating back to 1992 and linked to the treatment of civilians and journalists, and that is 6D129.
Kao I još jedan
And another document from 1995, which concerns a peace mission. Let's stay with 6D129 for the moment. From the text of this document itself, you will see that it is a document which Guerra compiled and sent to the cause. 6D129 is a copy which was received in one of the cores via a teletype, so they received a telegram in actual fact. It would be completely unnecessary and illogical for General Guerra to send this document to the cause from the main staff, and that somebody received it in a core and then confirmed by initialing it its reception, the reception of his own document. We wish to emphasize at this point that it is absolutely inadmissible for the prosecution to attempt in this way to link General Guerra to the mentioned documents. If the prosecutor wanted to prove and show Guerra's participation through his initials, then he should have and could have done this during the long trial by calling in an expert, handwriting expert, who would professionally analyze Guerra's handwriting and make his own conclusions on that. The prosecution deliberately failed to do that. And not only that, the prosecutor had every opportunity during the examination of witness Kral to directly put it to the witness that in this specific case it was in fact Guerra's signature, which, Your Honours, was the objection I raised at the time. And there was a suggestion by the president of this trial chamber that followed. The prosecutor once again chose not to act upon it, and this is on page 29346 of the transcript. With an absence of compelling evidence, the prosecutor is guessing and saying that the initials belong to General Guerra. That is insufficient because at the very least there is reasonable doubt as to who those initials, termed characteristic initials, actually are. Your Honours, to link up General Guerra's participation in the work of the Commission for the implementation of the peace agreement and to approve humanitarian aid, not absolutely interconnected. Because what would that standard of proof be? It would mean that somebody is guilty for trying to implement a peace agreement which is striving to achieve peace. Is that guilt? Is that blame? Your Honours, I will end there. Those are the facts set forward by me with respect to the prosecutor's allegations, and my colleague will continue. Thank you.
Thank you, Mr. Popović. Mr. Jos.
Your Honours,
Sorry about that. I'm just trying to make the conditions in the courtroom more comfortable. That's all.
Well, I'm sure I, being on my feet, particularly appreciate that.
Thank you.
Your Honours. I'm sure the registrar will deduct that from our time. Your Honours, there's only one other topic that I'm going to deal with in any detail at all, and then there are a few I'm going to deal with absolutely in passing. The topic, in a little bit of detail, is dealt with at paragraph 282, page 204 of the defence brief. And there we say the following. The defence say, as a starting point, that Milan Guerrero did not say that he would have the compound at Popović and the surrounding areas shelled. Of this, all concerned can be sure. Well, Your Honours, the defence was wrong about that because the prosecution's final brief on this very issue begins by continuing to peddle this patently incorrect line, and that's at paragraph 1781. It was wrong because, fortunately for Guerrero, the Muslims had intercepted this conversation and recorded it verbatim. That's P2374. And the plain fact of the matter is, Guerrero simply did not say what Nicolai alleged and what extraordinarily the prosecution continue to allege in their brief. It's almost as if they hadn't read the cross-examination of that witness. Now, Your Honours, the prosecution go on in their brief and seek to justify this by quoting from Nicolai's Assen debriefing note of the 18th of September 1995. And as a very minor aside, the quote at footnote 4309 is in evidence, but the actual document at footnote 4308 is actually not in evidence, and the same applies to footnote 4306. But getting back to the substantive point, the use by the prosecution of this debriefing quote is hopeless. I repeat what I have said. We know from the transcript of P2374 that Guerrero did not say what's alleged in the debriefing note. The debriefing note reads, quote, bombing the stream of refugees, the Popović compound, end quote. The fact that Nicolai was wrong about this so soon after the event only goes to show how mistaken and unreliable he is. And it was demonstrated to him, as I've already mentioned, in cross-examination that he was wrong. And I've already said, and I make no apology for repeating it, is nothing short of bizarre that the prosecution should continue with this line. We go on and say that this is highly illustrative of the very thing that Mr. Thayer, in his closing arguments, alleged the defence of falsely accusing General Nicolai of, namely bias. Now, it's either that or extreme confusion or both. You've heard me make some submissions about international witnesses. What I would say about General Nicolai is in response to Mr. Thayer's argument at 34080, when he took exception to what he called, quote, an absolutely baseless personal attack, end quote, on Nicolai. He claims there's no evidence of partiality on Nicolai's part. Well, we suggest that the error just alluded to makes that at the very least a possibility. But Mr. Thayer's defence of General Nicolai is really somewhat extraordinary when one contrasts what General Nicolai said and what Mr. Thayer says in his support with what General Smith said. And let's remember, General Smith was Nikolai's direct superior. Nikolai was his chief of staff. And General Smith's whole attitude and enmity towards the Bosnian Serb military leadership was something he really accepted, you may think. For example, he said in evidence that he wasn't prepared to negotiate with Mladic in June of 1995, whereas Janvier was, for example. He accepted extracts from Smith's book.
Who was for the transcript?
General Janvier.
Janvier. Okay.
He accepted, this is General Smith, extracts from his book, put to him, 6D186, where he said in terms that he was at war, or perhaps I should say he was effectively at war with Mladic, and that's at 17749 of the transcript. And you won't forget the quotation from Fortin's diary, the entry of the 10th of July, 6D165, which was dealt with in private session, and I won't repeat, which is at 17785 to 86 of the transcript. When you bear that in mind and what General Nikolai's superior was saying, is Mr. Thayer seriously saying that there isn't the remotest possibility, certainly remotest reasonable possibility, that General Nikolai was a tad bit biased, that he didn't quite perceive things in the clean way that Mr. Thayer alleges? Please bear that in mind when you come to weigh up General Nikolai's evidence. Now, whilst on the subject of the alleged threat, we submit as follows. The prosecution rely at 34079 on Nikolai's testimony that it was Guerrero's threat that made them decide to stop the airstrikes. We suggest there's clear evidence leading to a reasonable doubt on the issue. That's contained in our brief, page 205, paragraph 286, and in particular relates to Fortin's testimony that the airstrikes were suspended as a result of the VRS threat at 1400 hours read over the radio by the captured NCO. There's also pages 205 to 206 of our brief, paragraphs 287 to 289, that it was the Karaman's threat that led to the cessation of airstrikes, and that he couldn't recall with certainty whether or not the threat was transmitted by Guerrero. In the absence of certainty, we suggest, from the prosecution's main witness, any doubt must be accorded to the accused. Then at 34079, we had Mr. Thayer again asserting, quote, he had to know. And this was in the context of other threats. We suggest this is pure speculation based on no evidence whatsoever. It's rhetoric of the worst kind and indeed highly prejudicial and quite improper coming from a prosecutor. Now, Your Honours, the prosecution themselves acknowledge at 34079, over to the next page, that by the time of the second conversation, the one with General Gobillard, the airstrikes had already been suspended. By this admission, we suggest that they're accepting that Guerrero's second conversation couldn't amount to any kind of effective threat against Gobillard, leading to decisive action on the airstrike issue, as UNPROFOR had already made up their minds by the time of that discussion. And, Your Honours, at paragraphs 280 to 281, pages 202 and 203 of our brief, you'll see our assertion that the prosecution case on this issue has also changed. The case as opened, and in particular as indicted, where they only talk about a singular commander, was a threat against Nikolai, not against Gobillard. Don't let them get away with it, we suggest. They simply can't chop and change their case in this way. Related, but slightly different topic, is the warning that General Guevara sent to the Drina Corps immediately after these conversations on the 11th of July, which is 6D207. Both parties have set out their positions in their briefs, and Mr. Thayer mentioned it in his address. We suggest to you that the prosecution case, so far as this document is concerned, is that black is really white. They say that Guevara clearly doesn't mean what he says in that document. Well, of course, it's very easy for them to say that, but it's very difficult to prove, and it's something they have to prove beyond a reasonable doubt. We suggest they haven't got near doing that. Of course, what Mr. Thayer fails to address in his rhetoric to you is their very own expert on this particular subject, because Mr. McCloskey asked Mr. Butler about this document. And this is what Mr. Butler said. I quote, "This is a fair example of a good military idea that was overcome by events." That was at 19801. And Mr. Butler confirmed that again in cross-examination at 20722. Your Honours, a good military idea. How on earth can that be criminal and multifarious, as Mr. Thayer alleges in his submissions to you? Now, Madame Favreau referred to this document today in her submissions, contrasting it to the alleged Guevara order P45. She described 6D207 as an order. We submit that that's an incorrect description of the document, and that is one of the ways one can contrast P45 to 6D207. Our full submissions as to P45, of course, can be found in our brief at pages 216 to 221. I digress slightly to deal with that. One other thing I would like to deal with, whilst on a related topic, and that was something that Mr. Thayer ended with, and that was the intercept between Guevara and a man called Shubara, P1334, which was dealt with at page 134, paragraph 39 of our brief. And we say there is some similarities between that and 6D207, not in terms of the intercept in the document, but in the way the prosecution approached them. They simply say, and I make no apology for using the same phraseology, that black is white. And they can't give you any reason as to why black is white. They simply throw mud, that's what it is, mud at General Guevara, and they hope it's going to stick. And of course they have to say that, because otherwise their case simply doesn't add up and doesn't make sense. And bearing in mind the burden standard of proof, we are sure you'll have no difficulty in rejecting that sort of approach from the prosecution. Now, Your Honours, I'm going to go through a few more issues much more briefly. I think there's one I can deal with before the break, and that is the alleged intercept between General Guevara and Radovan Karadzic. This was dealt with in closing at 34082, and the prosecution complained that the transcripts that we were relying upon do not mention, they complain that we have falsely portrayed 6D14 and 6D15, the transcripts that we refer to in our brief. Your Honour, the trial chamber can feel confident upon the accuracy of the contents of those transcripts. They were played in full to the relevant witness, PW145, during his testimony, and he explicitly confirmed at 7264 that their contents are identical to the conversations in the intercepts. Now, as such, although only Guerrero's side of the conversation has been recorded, and therefore it's only his part of the conversation that appears on the transcript, it's very clear that the record of the call commences from the beginning and also includes the portion of the conversation with the operator. As such, you can feel confident and indeed able to verify independently that nowhere in those intercepts is the name Karadzic mentioned, either by the participants during the conversation.
Please slow down.
My apologies. You can feel confident that nowhere in those intercepts is the name Karadzic mentioned, either by the participants during the conversation or by the operator at the beginning of the call. We suggest, as set out in our brief at pages 193 to 202, that PW145's purported identification of Karadzic as the other participant in that conversation, and the fact that it appears in the headers of P1096 and P2375, the transcripts the prosecution rely upon, is or may be based on a series of mistaken assumptions and cannot be relied upon beyond reasonable doubt. Significantly, PW145 admitted during his live testimony that he could not be sure of the participants in the conversation. Briefly on this topic, at 34083, Mr. Thayer characterized one of these discussions, I think it was P1096, as short, curt and polite. And he said that this establishes that this is a call with Karadzic, somebody with whom he has, I haven't got the quote here, but Your Honour has the page reference. We submit that Skrbic's evidence is diametrically opposite to the assertion made by Mr. Thayer. Skirbic described the call as a friendly exchange and was symptomatic of a, quote, relationship full of respect. And that's set out in our brief at paragraph 261, pages 1934. We say that couldn't apply to a conversation between Guerrero and Karadzic for reasons the trial chamber are well aware of. With Your Honour's leave, perhaps we could take the second break now.
We'll have a break of 25 minutes. Thank you.
All rise for your overlevy.